Can the courts go on and reshape the criminal procedures? Can a court pause arrest in domestic cruelty cases for 2 months? Recently, Supreme Court has just done that in Shivangi Bansal versus Sahib Bansal case. It is a classic case of judicial experimentalism. Let us understand what NRCB data tells us and where the law should go from here. Hello everyone, welcome to Vajiram and Ravi's Flash News. Let us begin by understanding Section 498A as well as the new Supreme Court ruling in the Shivangi Bansal versus Sahib Bansal case and why it is being called. Then we will move on to understanding that why it is being called a classic case of judicial experimentalism. When we talk about Section 498A of Indian Penal Code, which is now Section 85 of Bharatiya Nyaya Sanhita, basically the historical background, if we go into that, we get to see that this was enacted in 1983 and the whole idea of this enactment was to address the cruelty that was done by husbands or relatives against female. So when we are talking about this particular section, this addresses any sort of physical, mental cruelty that is likely to drive a woman to suicide or cause any grave injury itself, or if there is any case related to harassment due to dowry, that is also covered in this particular section. When we are talking about this particular section, this forms the fundamental basis of understanding the new Supreme Court ruling that has come out. Now, when we are talking about this particular judgment in the Shivangi Bansal versus Sahib Bansal case, this is also an affirmation of an earlier case which was running at Allahabad court. Now, that case was Mukesh Bansal versus State of UP in 2002, and the judgment which was given in that case and the recent judgment, they are on very similar lines. So, in this recent judgment by Supreme Court, there has been introduction of a 2-month cooling period after a complaint has been filed in the Section 498A, or we can talk about Section 85 of Bharatiya Nyaya Sanhita, and that provision has been introduced by the Supreme Court. Furthermore, if there is a complaint, then that complaint will be forwarded to Family Welfare Committee and no arrest is allowed to be made during this interval of 2 months unless there is any sort of special permission. Now, the reason, if you want to understand why Supreme Court has done this, this is all about not allowing the misuse of this particular section or any unnecessary custodial arrest. But the question does not get over here itself because it will directly harm the victim's right to get redressal. In this very context, we will get into the details, understanding the issues that might crop up and the concerns that lie in front of us with regard to this particular judgment itself. Now, when we are talking about this particular judgment, it becomes significant not only because of the cooling period that it is offering, but also because of the fact that it creates a pre-arrest layer between the victim and police investigation, and this is showing a major shift in the crimes and the investigation related to domestic violence and dowry cruelty enforcement. Now, this judgment is also being seen that it might affect the issues which need redressal. Even at present, the numbers of cases in terms of dowry cruelty and domestic violence are huge. When we are talking about the arrests made in such cases is not even 1/3 of it, which has been shown in the recent data. So, this ruling where it tries to curb the misuse of the section, it might also curb the actual requirement of this section that is present in our society. Now, let us move to the main point that we started with, that is this a classic case of judicial experimentalism. So, when we talk about judicial experimentalism, we have to distinguish it from other terminology such as judicial activism, such as judicial overview and judicial overreach. When we are talking about judicial activism, it is basically the proactive role of judiciary in protecting citizens' rights and promoting justice in society itself. But there is another terminology very close to it, that is judicial review. Usually we get confused in all these words. When we are talking about judicial review, it is basically when judiciary understands and checks the constitutionality of the legislative enactments as well as executive orders either by central government or state government. And then we have judicial overreach. This is when judiciary oversteps the given framework of power it has in terms of maybe encroaching or disturbing the framework of separation of power, maybe taking up the work related to legislation or executive organs. That is when we consider it judicial overreach. Now, when we will understand judicial experimentalism, you will find that there is certain amount of overlap when we are talking about judicial overreach and judicial experimentalism, because this is the scenario in which we find that courts usually create new procedures or institutions which are not expressed in statute, which are not already given in law, to bring solutions to the social problems. That means when we are talking about family working committees, when we are talking about 2-month cooling period, this has not been mentioned in law. This is an experiment by the Supreme Court, which was earlier given in a judgment by Allahabad High Court as well. It is an experiment of creating of institutions or procedures to solve social problems. So it is very close, it lies very close to the forms of judicial overreach. And when we are talking about 498A context, we have seen past instances where such judgments have already been passed. When we are talking about Rajesh Sharma versus State of UP in 2017, Supreme Court had set up FWCs in every district, and it also talked about 1-month cooling period before arrest. However, this decision was quashed later in Social Action Forum versus Union of India 2018. Basically, it said that Supreme Court or the courts in terms of deciding FWCs and embargo, that is beyond judicial power, and it is undermining victims' right to get an immediate recourse and redressal. So this experiment has already been done at the apex level and it has already been quashed, but in the recent case of Shivangi Bansal, the idea of FWC has been revived, the idea of cooling period has been revived, and it has gone further to be increased to 2 months, which raises the direct question related to constitutional issues about the facts such as separation of power, about Article 21 in terms of victims' rights. It also talks about right to speedy justice, delusion of statutory police powers under CrPC. Now, these are the contexts in which the Supreme Court judgment is in a way diluting the rights which are available to the victims here in this particular situation. And this can be very well understood when we see the data present in front of us. So if you see the number of arrests that has been made in these specific registered cases of 498A, you will find that there is a stark difference and decline over the years that has been seen. Registered cases and the arrests that have been made in this very context. That is why the misuse concerns are high. And we need to also understand that the safeguards which are present. When we are talking about perceived misuse, the whole idea when we see there is an increase in false and exaggerated complaints, the harassment of husband's family, and there are heavy arrest rates, that is what has been concerning. But when we talk about the legislative and judicial checks that are already in place, you will be able to understand, for example, Criminal Procedure Code of 2008, that the arrest will happen only if necessary and when the reasons are recorded. Another judgment, for example, Lalita Kumari versus Government of UP, it also talked about in 2013 itself that preliminary inquiry that was permissible in a matrimonial case, that too just before FIR. So these safeguards have already been in place which do not affect or do not dilute the whole idea of extending help and giving immediate redressal to the victim itself. Furthermore, if you look at another case here, that is Arnesh Kumar versus State of Bihar of 2014, there has been a provision of mandatory checklist before the arrest is made, especially in the cases of 498A and dowry cases, and the preference has also been given to notice of appearance over immediate custody. That means if the notice of appearance is being issued out, then it should be the first priority rather than going for the custody itself. Another important judgment, when we talk about Satyendra Kumar until of 2022 case, if the arrest is made bypassing Arnesh norms, this notice of appearance is not taken, the preference rather you are going for immediate custody. That means in that scenario, an automatic bail provision is available to the person in which the arrest has been made. So there are enough safeguards in place, and putting such a scenario where there is a 2-month of cooling period and a provision of arrest after the final judgment from FWC, that complicates the procedure and dilution of justice can be seen. So because of these safeguards, there is a proper balanced approach that has been maintained. There in these scenarios, we see that there is no knee-jerk arrest, but at the same time, there is a prompt relief to genuine victims that is seen. So we need to make sure that in these scenarios, this is the approach rather that is followed, rather than focusing on curbing misuse, which also leads to the curbing of the rights which are available to the victims itself. Now, if we talk about the arrest and complaints, you will find in this scenario that arrests have fell by 22%, and the evidence clearly suggests that existing guidelines already are focusing on reducing indiscriminate arrest without discouraging victims. So this Supreme Court judgment, where it talks about curbing the misuse, there are multiple concerns related with it in terms of cooling period, because it not only delays the prompt redressal by 60 days, there is no legislative backing that is given to the provisions that have been mentioned in this particular judgment. It dilutes the autonomy of police, where CrPC is interested with investigation and arrest powers, and the judicial add-on will clearly blur the boundaries that are present in separation of powers that we see between the organs. And last but definitely not the least, that is the reversal of 2018 precedent that was set by Supreme Court itself. So basically reintroducing a measure that had been talked about by Supreme Court itself, and that can be understood as regressive. Now that was all from my side. What do you think about this Supreme Court ruling? You can let me know in the comment section. Thank you so much.